gratitude. First, recognition that we are on traditionally Native Indigenous lands, and I'm sitting and joining you from my office at the University of New Mexico, which sits on Native land. I also want to thank Josh Bradshaw for his tremendous work in pulling this together, and the Black Leadership Council, and Amy, and of course OAAA generally for their work on this issue. I'm honored to be here, and I'm looking forward to hearing and learning as well. I plan to talk about the role of, in particular, school alleged safety measures and the disproportionate impact on Black and Brown youth. I'd love to go ahead and share with you my slides. So I will do that here. While I do that, I'd love to tell you a little bit about myself. So I did grow up, I was born in Chicago and raised in the suburbs. I lived in Washington, D.C. for many years. And I had an opportunity while I lived in DC to teach in a number of public high schools, as well as direct a program where we train law students to teach high school students about their constitutional rights and responsibilities. Through that work, I had an opportunity to observe and help build coalitions in cities all across the United States to start similar programs where law students go in and teach high school students about their constitutional rights and responsibilities. And we teach in schools that are predominantly urban schools, predominantly regular public schools, some charter schools, but mostly regular public schools, and mostly majority minority schools. So I've got a lot of experience in observing these practices, you know, firsthand. And unfortunately, that my observations led to the research that I've done for close to 20 years now, looking at the effect of some of these alleged safety measures on children of color in particular. And I'll just say that I am the mother of a multiracial child and very interested in this issue also from the standpoint of being a parent in Albuquerque. So in terms of this issue of school safety measures and what we're currently doing, what we can do better, this is what I'd like to cover. Why does this topic matter? I suspect I don't have to tell anyone in this room why it matters, but I will just highlight a few things. I also want to talk about define what I'm talking about when I talk about school safety measures, and I use that term in quotes for those who might just be listening rather than watching along with the slides here. I will then talk about whether these safety measures actually keep students safe. And then I will really focus on the constitutional concerns, which is where my scholarship really focuses on. I'm a lawyer a teacher who happens to be a lawyer. And so my interests are really the Constitution and constitutional protections for all people living in the United States, but in particular students, public school students. Then I want to talk a little bit about what interventions we know work. So in terms of data points, we know that Black children are nationally 2 to 3 times more likely to be suspended or expelled than their white peers. We also know that in New Mexico, and thanks to a Kids Count special report that was produced in 2018, we know that Black children in New Mexico are at least as likely, and actually according to the report, 4 times more likely to be expelled than their white peers in New Mexico. We also know that nationally, children who identify as Black or African American constitute about 36% of arrests, school-based arrests, which is very disproportionate to their representation in the student body, which is about 15%. So that's some data points. We also know that there's a very deep interest in the law in doing a better job of teaching children and more effectively treating students equally and making sure their outcomes are equitable as well. And we have this recent case of Yazzie Martinez, which I think many of you, have heard about, know about. And I want to just highlight the importance of Yazzie Martinez in this context, that there's a lot of overlap in identities of the children that were identified as being denied their right to education under the New Mexico State Constitution in that case. So in particular, there are students who are biracial or multiracial who may be affected, you know, by the decision. There are also students of color who, including Black students, who may have been diagnosed with a disability that qualifies them for special protection under Yazzie Martinez. And we also know that children living in poverty are covered by Yazzie Martinez. There's some estimates that about 3/4 of all public school children in New Mexico are affected by the Yazzie Martinez case. And so that certainly looms large in our interest in this topic. Also, we know that recently New Mexico finally passed the Black Education Act in 2021, which was built on the Indian Education Act and or sort of developing out more protections for Black students in particular, you know, in the wake of the Indian Education Act and the Hispanic Education Act. Recently, since the summer of 2020, when there's greater call for equity, particularly in policing and harsh policing against Black Americans, there have been similar calls nationally and here in Albuquerque for protection of children in schools and diverse children in schools. So I have a couple of headlines here of articles addressing that concern about harsh treatment of children in schools. We care about this issue because discrimination is a weed with deep roots. I think sometimes we want to just cut the surface off, you know, maybe mow the lawn, but we don't realize that there are very deep roots. And in my view, systemic problems with deep roots need systemic solutions. So my work looks at, again, these very broad constitutional protections with that goal of trying to create greater equity on a very large scale. Now, in terms of school safety, the real big constitutional balance is between individual privacy and security, or community security and safety. That's the big balance. There's no right formula for that. It's always a question of how do we balance our privacy interests, our children's privacy interests, with the security in schools. And I just want to put some more data out to highlight, you know, my understanding of this issue. So you all may know there are about 50 million children that go to school every day in the United States. And, you know, what these very intrusive measures are aimed to do is to address a tiny, tiny fraction of instances of violence. And so in the meantime, millions of children are going through and experiencing these practices that I have up on the next slide every day. So they're experiencing, and many children live in communities that have negative interactions with law enforcement over policing. So having police officers in their schools is immediately a scary and negative experience for many children. We know that many schools also have cameras, drug sniffing dogs, metal detectors, and those particular practices in this bullet point in white, I align with the Fourth Amendment's protection against unreasonable searches and seizures, and I'll be talking about that more in a minute. So these colors are purposeful. The yellow bullet point talks about threat assessments, which are, you know, there's a tool now to develop kids as young as 5 and 6 years old, making statements or even engaging in behavior that concerns adults in the school. And then we do these threat assessments that are modeled on the system that the Secret Service designed to protect the president from assassination attempts. So we're using similar tools in public schools to assess whether 5-year-olds are going to engage in that level of behavior. We also engage in questioning at schools that can have criminal consequences without parents or counsel present. And these two practices, threat assessments and questioning at school, relate to protections under the Fifth Amendment against due process violations, or that we're guaranteed certain protections if we're deprived of education in school. And then, you know, the questioning piece aligns with the privilege against self-incrimination that's protected by the Fifth Amendment. Next, in purple, you'll see restraint and seclusion, which is a practice that stubbornly persists around the country, including here in New Mexico. And Congress is working on efforts to nationally ban restraint and seclusion, or at least limit the implementation of these practices, which are known to have produced deaths and serious injury of students, generally students with disabilities, and sometimes students of color are subjected to these practices when they are, again, engaging in behavior that adults feel might be harmful to those children or others. And I argue that restraint and seclusion violates the Eighth Amendment's protection against against cruel and unusual punishment. Finally, in Black, you'll see children of color and children with disabilities are funneled into the criminal legal system at higher rates because of these prisonization practices that I've identified. And I use the term prisonization that I coined in an article in 2017 called The Prisonization of America's Public Schools. And the 14th Amendment, as many of you know, guarantees equal protection under the law. And so I argue that this practice of funneling children into the criminal legal system at much higher rates violates that protection. Now, in terms of this question, because I think this is the elephant in the room, lots of people, maybe some of you even are thinking, well, if we have to engage in those practices in order to keep children safe, maybe in balancing out the individual liberties and privacy against security, then it's okay. And the truth is that we don't really know the answer to this question because it's very difficult to assess, right? How do we know that school A that started using embedded police officers and metal detectors and maybe other practices as well is safer today than it would have been today if it didn't have those practices? We can't really know the answer to that, but there is some data to show that these measures do not necessarily lead to safer schools, and in fact further harm children, a much larger number of children, particularly children that we're most concerned about, children of color, children with disabilities, children who are non-US citizens. And so in my view, there are other things we can do that we know are evidence-based to create safer schools. And so I'll get to that in a little bit. I already talked, the next slide talks about these constitutional guardrails, which I mentioned in my more recent article called School Safety Measures, Jump Constitutional Guardrails, that was published last year by the Seattle University Law Review. And so I invite you to take a closer look at that article if you're interested. I'm going to talk a little bit more about the particular cases that, that address these protections. So if you'll follow with me on this slide, there are really 5 or 6 major cases. In the Fourth Amendment context, in 1985, the Supreme Court decided for the first time that students do enjoy Fourth Amendment rights in schools, that the Fourth Amendment's protection against unreasonable search and seizure does apply in public schools. However, they decided that a lower standard of suspicion is applicable in the school context because it's sort of a special needs circumstance, according to the court. So rather than, we all know, we've heard about probable cause as the general standard for justification of a search or seizure, and generally a warrant based on probable cause. But in schools, reasonable suspicion is all that's needed. And there's a two-pronged test from the TLO case to determine reasonableness, which involves whether the search was reasonable at its inception, and secondly, whether it was reasonable in its scope, or did law enforcement or school officials go too far. So there are a few other cases that the Supreme Court has decided with regard to the Fourth Amendment's applicability in public schools. This middle two, Vernonia versus Acton and Potawatomi County versus Earls, dealt with drug testing of student athletes in Vernonia, and then in Earls with students involved in extracurricular activities. So in both cases, students were asked to sign waivers allowing school officials to subject them to random urinalysis testing. And the court in those cases applied the TLO test and said that because of the strong interest in preventing drug use in schools and because of the leadership role that sometimes these students play, that it was okay, these policies were okay. However, in Safford versus Redding, the court decided that a school went too far and did violate the Fourth Amendment's ban on the Fourth Amendment's prohibition of unreasonable searches and seizures by strip searching a student that it suspected was carrying basically over-the-counter medications on her person, which it turns out she wasn't. But the point of these Fourth Amendment cases is the court has really applied reasonable suspicion and applies this two-pronged test. Was it reasonable at its inception, and was it reasonable in its scope? In the Fifth Amendment context, we know, I mentioned there's a protection for procedural due process. So there are certain procedures that are owed to us when the government deprives us of life, liberty, or property. And school has been considered to be at the very least a property interest. We have a property interest in school. And so when a child, pursuant to the Garces-Lopez case in 1975, when a child is subject to discipline that might result in 10 or more days of suspension, then they are entitled to notice and a hearing. They're relatively informal in terms of what they require, the notice and the hearing that's required, but still, schools must provide notice to families when a child has been accused of an infraction, and also there must be a hearing where the child has an opportunity to put forth their point of view and not just be punished without any explanation. Now, in JDB versus North Carolina, the court for the first and only time considered whether questioning of a student for a crime that was reported to have happened off campus was appropriate, whether it was okay to question a student at school. And this was a 13-year-old child who was diagnosed with special needs. And the court in that case said that in determining whether a child is entitled to be read their Miranda rights, and I think we're all familiar with those, that in order to determine whether a child should be read their Miranda rights, in other words, whether they're in a custodial interrogation, that the officer should consider age in that determination if they knew or should have known the child's, or roughly the child's age. And the idea there, of course, is that young children would feel more likely to be in custody with an authority figure. Then in the Eighth Amendment context, the court said that there are no protections against cruel and unusual punishment in schools in a case called Ingram versus Wright in 1977. The reason they said that is they said that that protection only applies when we are in prison or prison-like circumstances. So I very purposely called my 2017 article, The Prisonization of America's Schools, to describe all these practices and make the argument that we now have a situation in some schools where children are not free to leave in the way that they used to, that many of us used to be able to. And so therefore there should be protections against cruel and unusual punishment. I'm going to be talking more about some of those practices, but I do also just want to make sure we know that the Supreme Court did not ban corporal punishment. In Ingram v. Wright, they said corporal punishment is not up to us to decide because schools are not prison-like circumstances. And we should know that New Mexico just banned corporal punishment in 2011. Prior to that, it was okay for school officials to, hit children in schools. And there are still 19 states in the United States that allow for corporal punishment. Finally, in terms of equal protection, Brown versus Board of Education, of course, is the seminal case here where the court decided that separate is not equal in education. And so I argue that because we know that these prisonization practices lead to the involvement of children in the criminal legal system, that there's a violation there of that equal protection guarantee. And in order to justify prisonization practices, the school must meet strict scrutiny. They have to show that they have a compelling interest, which I think, arguably school safety could meet that requirement, but also that the policy is necessary to achieve that interest. And that's where I argue we have some wiggle room. I'm just, in the interest of time, I want to move a little more quickly here. So stare decisis is a concept that has come up a lot in the news, especially lately with regard to the abortion decision that the court is going to hand down shortly. The court does overturn its prior decisions despite this guarantee of stare decisis, and it has in 300 separate cases in the history of the Supreme Court. It has overturned itself. So I argue that there are lots of reasons that the court should consider expanding the protections against these practices for children, given that we know that there's much more police presence in schools today. About half of schools in the United States have embedded school police officers. We know that there's better research on how children develop, how their brains develop. And we know that we have much greater concerns about institutional racism and awareness of these practices. There's also an interest by the court. They've demonstrated an interest in concerns of individual privacy with regard to policing. So in a case about GPS tracking, the court slapped down the District of Columbia Metropolitan Police Department, which was tracking a suspect beyond the amount of time they were allowed to. And they talked there about how much data is gathered in that tracking process. They also have eliminated the opportunity for officers to search cell phones indiscriminately pursuant to arrests. So finally, I want to just mention some of the systemic solutions, and I know we'll get to talk more about this in the a little bit later in this hour. It's really, really critically important that we understand how systemic these problems of racism and over-policing of schools are. We must learn to value the voices of every single child, particularly children of color, because of all the microaggressions and other challenges that they uniquely face. So I argue that creating cultural awareness and appreciation curriculum standards is a step in that direction, and I know we're in the process of doing that here. We also need to, though, implement mandatory and ongoing anti-bias training and resources, not only at the leadership level, but also at the classroom level. Every person who interacts with children, in my view, should be able to and required to undergo training about bias and ongoing training about bias. We need to eliminate harsh discipline practices like restraint and seclusion. We need to consider the role of school police. Certainly there are times where school officials should call police. But in terms of embedded school police, the instances with very serious violent potential are so limited relative to the risks that police provide in schools. And then finally, and very importantly, we need to support school-based mental health. And I know we're working on that. I just did a quick search to find out where we are with regard to school social workers, psychologists, and counselors, which we know from the Yazzie Martinez case in New Mexico, we're way below national and recommended standards for the presence of those folks in schools. And I know that we're working hard to try to recruit people for those roles. I argue that we should be, really focusing on that rather than school police. I know that we're looking for remote support, and I think that's a step in the right direction, but I don't think it goes far enough. I think we need in-person folks, and I know there are lots of limitations for that. So finally, I know there will be questions and comments, and we won't have time in this hour to address all of them, but I do hope, I have my email up on this last slide. I do hope that anybody who's interested in learning more about my research or just questions that you think I can answer for you, that you'll reach out to me and let me try to answer them for you.
Thank you so much, Professor. That is a really great insight into what's happening to our youth in schools. Really important for us to keep this conversation going after hearing all of that you presented. There are two really quick questions before I turn it over to a conversation with you and Senator Pope. The very first question is there an example of what sort of behavior usually merits 10+ days of detention? That is an awful lot. I think all of us are shocked and amazed at that. So, what are students actually giving a hearing and when they are not?
Yeah, so Amy, that's a great question. Very important question, because by the way, I have heard of cases where to try to avoid any of the due process protection, schools will just give 8 or 9 day suspensions, or they specifically limit the amount of potential punishment to avoid having to get into the back and forth with families. But typically, it's a very serious offense, and it's typically not the first instance of misbehavior, I would call it. And so it could be bringing some kind of weapon to school, a knife or something like that. I mean, it's not still very common that children will bring guns to school, although we know it happens sometimes. Threatening other students, serious threats that seem like there's some teeth to the threat, could merit that kind of punishment. And I suspect that APS, most school districts, I could look this up real quick, but most school districts have their discipline policy very well laid out for parents to know. And I suspect probably PED does as well, have links for all over the state in terms of different school districts, the discipline processes and what types of behavior would fall into different categories of punishment. And so I'm happy to look up some links if you'd like, while we're here together.
Really appreciate that information, right? I think so many of us are nervous about what's happening in our schools, and very often it seems like we're not very clear on that. And what our students' rights are. So there are other questions in the forum and we will come back to those. But first, I really want to invite Senator Harold Pope Jr. into the conversation. We really wanted to bring him on to help us discuss the potential policy and program solutions for New Mexico. Senator Pope currently serves as the New Mexico State Senator for the 23rd District, that's in Bernalillo County. He is a veteran of the United States Air Force, served as an officer and retired at Kirkland Air Force after 20 years of honorable service. During and after his military career service, he has served in leadership and volunteer positions in several nonprofit organizations, both locally and within the region. And so we are very interested in hearing from the two of you, conversation about what potential policies and programs we have for how we can move change forward for our youth.
Thank you, Amy, and thanks for having me, and thank you for the presentation, Professor Ahranjani. That was great. I love coming to these as well because it helps me really learn as well and see what we can do at the Roundhouse. So I have a few questions and I'll go ahead and get started. Question one, in your presentation, you mentioned that institutional discrimination is like a weed, and systemic problems need systemic solutions. Using the weed example, my interpretation of pulling weeds is that if you don't pull it out by its roots, the weed will just grow back. It also takes water that's intended for other plants to grow. What are some of the policies and programs that you've seen in your research work at getting at the root of this problem?
Thank you, Senator Pope. It's a great question. I think it's important that we, there are state and district level anti-racism policies. I know a lot of times we use the term equity to talk about anti-racism, and I hope that we can be even more specific and intentional about racism. I think it's important to put a name to what our children experience. So I do think that, though, what we can do a better job of is implementing policies at the school level, or developing policies rather at the school level. We know that children of color sometimes are more densely populated in particular schools. So it's important. I mean, this should happen in every school, but I think schools can come together by developing anti-racism policies just for their particular school environment. I also think, removing on-site police, there's no question that that is the direction in which other districts across the country are moving. And again, it doesn't mean that we don't sometimes need police in schools, but their mere presence, unfortunately, does lead to regular behavior in schools being criminalized, particularly for Black children and other children of color and children with disabilities. I think it's important systemically that we not just say the words inclusion, but that we really mean it at every school level. And that is hard to quantify. It's hard to systematize, what inclusion means. But there are ways to to try to get at it, which I'll be happy to talk about in a second with your next question.
Right. Thank you. The second question would be, follow with the last question. What is an intervention or policy change that you believe will have the most immediate impact?
Yeah, so I think this is a great question, and I'd like to bridge my comment about inclusion to my answer to this question, which is that it's important to collect data, again, at the school level, and not data that someone's telling you have to collect, but you know, schools that I've seen that have been able to reverse climates that are highly negative for children of color conduct regular climate surveys, and they're anonymous, and they give families an opportunity to share what their children are experiencing. And I think it's important that school leaders not only administer these climate surveys, but they do them regularly, and they actually read every single comment and make community conversations around the findings. You know, just be transparent about what the results of these climate surveys are. You know, we know that bias is part of the human brain. It's something that we all engage in. It's, you know, our brains receive way too much information every day to be able to process it all without creating shortcuts and creating assumptions. And so we're all honestly always working to be more inclusive and to eliminate bias. And if we can all recognize that that we have the capacity to be discriminatory, that we have to really be honest about that, but then also, okay, so what do we do about it? What, you know, and hear from families about what they think needs to be done. So I would say, you know, climate surveys and in general, gathering data and responding to the data.
Thank you.
Sure. May I ask you a couple of questions, Senator Pope?
Sure.
Okay, great. So my first question is, we've seen racial impact statements pop up around the country, and making legislatures view a statement that describes the potential impact that a law may have for different racial communities is the driver of these racial impact statements. I wonder whether you see racial impact statements as a potential solution here in New Mexico.
You know, I look at them as, you know, maybe part of the solution, because it depends how they're implemented and what we do as legislatures, as far as a legislature and the policy, and what we do with that information and data, of course. You know, I like to get this information. Currently, we do this right now for impact statements on the fiscal impacts, the educational impacts. You know, I even have pushed in the past for this to happen on environmental impacts of things that we do. And I sponsored legislation like the Green Amendment to do that. Of course, there are some people who are opposed to this. They believe that it gives minority communities, marginalized communities, maybe too much power to maybe stop legislation. But I would defer on that. I would think that we would look at the legislation, and if it impacts them, maybe we can make the legislation better or ensure that it doesn't harm those communities. But here in New Mexico, in the Black community, just like Asian American communities, other communities, we're just not being looked at. And so I would really support us doing something like this here. I know there is going to be pushback. Look, I'm dealing with a lot right now where everyone wants to make everything CRT that deals with anything racial right now. But we need the community to get behind us to get this done. And maybe this is something that we could get done initially as a pilot program, which I think would be great. And maybe we do that. But we're going to need help getting this done. Just a little information in this room, and I want to let everyone know. One thing I find in the legislature that happens is this. The Black Education Act passed unanimously. You'll see that with the Indian Education Act. You'll see that with Hispanic Education Act, where everybody supports it and votes for it. They might not like it, but they vote for it. But what I see is people don't want to look as if they blocked legislation for anything from a certain community. But when we have tried to pass, for example, looking at institutional racism or looking at multicultural education, then they really try to block it and stop it. So I just think folks need to understand that, and that's what happens. And I think they need to know that and understand why sometimes it happens this way, these separate bills, when it really shouldn't. But that is a dynamic that I deal with in the legislature.
Thank you for sharing that, and thank you for continuing to fight even in the face of those challenges. So in 2020, the New Mexico State Legislature passed House Bill 43, the Black Education Act, and a portion of it requires the development of district policies that address and have consequences for racially motivated incidents. Also, an annual anti-racism and racial sensitivity training or professional development for all school staff, and a developed hotline used to report instances of racism directly to the person at the hotline and NMPD. The passing of this bill was a good first step, but what would be the practices to hold school officials and campus police accountable? So could you please talk about the process that led to the writing of the bill, its importance, and the impact it's starting to have, as well as, what the next steps should be?
Sure. First off, I was elected in 2020, and I know this was a long process of community members and the work of Majority Leader Stapleton and really bringing this across the finish line. I was lucky to come in 21, my first session, be a co-sponsor, and being able to get it done and really get it passed on the Senate side. But this really came from the community. People telling their stories, students, families that were impacted by what was going on in our schools. And that's really where the best legislation and policy comes from, really that bottoms up approach and not coming from top down on what I believe or what I think should happen. And so that's how this was developed. And this is how really it was pushed, and really just getting the community behind it. The Office of African American Affairs, nonprofit groups, African American groups in the city really supported this. And seeing that there was already a Hispanic Education Act and an Indian Education Act, and just for years, even since I moved out here, the tricultural myth and the fact that people have to go to college to kind of learn about their history is just wrong. And it's happening really in too many places, but especially here. And I just, I grew up in Southern Colorado, but it's a similar thing where you go to school where it's a low percentage of African Americans, and you just do not feel included. You don't really, in a way, feel part of the community. You don't see people that are successful or people in higher positions that really look like you. And we don't need that happening to people in our community. It's just not right. It's not fair. So I would just say that's really what happened coming from the community. Community got behind us and passed it. I will say in the end that we need your help to make sure this gets implemented. It's a little bit about what you were talking about earlier about policy at the local level. And honestly, I struggle with that a little bit because I want it at the local level, but we end up passing things at the state level because guess what? They're not doing the right things at the local level, right? And that's something that we really have to watch out for, is how is this really being implemented in the school districts? Is the cultural relevant education being taught? Is the phone number and the hotline being promoted, right? So we can pass everything all along, everything that's great and sounds good, but if it's not implemented, what does it really do for communities? So that's what we're going to need help on. Finally, I like to say on that bill, it's under attack right now. If you're watching what's going on right now in the governor's race, Mark Ronchetti is actually targeting the Black Education Act as CRT and saying that Representative Dow voted for CRT and that's the bill. So I just want the community to know that that's what's happening, and I'm pushing back on it. People are pushing back on it, but we have to push back on this because after this election, I just worry about the long-term harm of what we passed because I fear that with this rhetoric, there's going to be some schools and some school districts that are not going to implement what we passed. And it's important that we ensure that African-American students across the state are being protected and being taught, and the teachers in those schools and school districts are getting the proper training needed.
Thank you, Senator. I think, right, that is so important, is that we ask you all to do that work for us, and then we have to follow up with some work on how do we make sure that it's being implemented correctly. So there is a question in the Q&A around, can you speak to what the legal standard is in order to search a child's person and how detailed that search can be? Thank you so much for putting in the chat the link to the New Mexico school discipline laws. And I want to encourage anyone who has not seen our school discipline laws to go to that link right now. But can you tell us about that legal standard?
Absolutely. So the case that I mentioned, New Jersey versus TLO, involved a young woman, a teenage girl who was suspected of smoking. And she had a purse, was supposedly smoking in the bathroom with her friend. And so she had a purse and ended up being searched by the vice principal, the vice principal, on the basis of this tip that she was smoking in the bathroom, said, "I'm going to search your purse." He opened up her purse, found some items in there that that seemed to indicate that not only was she smoking, but maybe selling marijuana. So continued to search in the purse to the bottom of it, where he found a list of names, some dollar bills, and then, you know, ended up referring her for criminal investigation. So now, the court found in that case, again, that as long as a search is reasonable at its inception, meaning there's reasonable suspicion to believe the child is engaging in, you know, unlawful conduct or conduct that violates the school code at least, and that the search is reasonable in its scope, so that they don't just go ahead and, okay, they found, you know, cigarettes in her purse, they can't go ahead and then strip search her, you know, or you know, maybe do something even more intrusive, you know, like a urinalysis testing or something else. The Supreme Court, by the way, has never dealt with the issue of locker searches, whether locker searches are protected by the Fourth Amendment in particular, but lower courts have generally upheld locker searches. They've said that children don't have any expectation of privacy in their lockers, that the lockers belong to the school, and if you choose to put your items in the locker, then you sort of, you know, are acknowledging the risk that school officials might search your lockers. So in a nutshell, again, there is protection. The school has to have reasonable suspicion in order to search your person or your belongings, but it's a pretty low threshold, you know, and if it has anything to do with drugs, courts really seem to defer to school officials in terms of you know, trying to figure out whether the child actually has drugs on them. That said, we do have that, you know, the bookend of the strip search of the young woman in Safford versus Redding in the most recent case, in which the Supreme Court said you can't just strip search a child, you know, for suspecting that they have pills on them. And in that case, again, it was over-the-counter pills. So, but so there do seem to be some general guidelines. But in general, they're just going to have to meet that reasonable suspicion standard at its inception and in its scope. Does that answer the question?
I think it does. I'll let them put something in the chat if they have a follow-up to that. I think once again, right, it's really difficult for any of us to really discern what exactly are the students' rights. And so one of the other questions we have here is, are students questioned without their parents, and is that acceptable?
Yeah. Unfortunately, the Supreme Court did not. They could have said in JDB versus North Carolina, they could have said, you can never question a child without at least notifying the parents. They could have said that, and they didn't say that. The best practice, I think anyone who is an educator hopefully cares about young people and the possibility that they could say something that is actually incorrect, that ends up incriminating themselves. And there are lots of studies about this, by the way. Most people, law-abiding citizens, are likely to say that they've done something, even if they didn't, just because of the pressure of the coercive environment of being questioned by a police officer. It is still, you know, I teach that in my criminal procedure class, and it's still like surprising to think about that we, you know, that they're false confessions so frequently. But children are even more likely, because of their brain development, not understanding the longer term consequences of making a statement to a police officer, just wanting to get out of the situation, right? They'll say whatever they need to get out of it. That we know it's even more important that they have their parents present. I actually would need to look at PED and APS policy to see whether we have any restrictions. We certainly can provide more protections for children than what the Supreme Court has provided, and some schools do. And actually, New Mexico generally, we do provide greater protections for people accused of crime than the federal Supreme Court has required under the federal Constitution. So it would make sense that we do that for young people as well. But again, I don't know off the top of my head. I'd have to do a little bit of research to see whether we ban questioning of children. Based on what I've heard and read, I think that it happens. I think that it does happen. One thing to keep in mind, we haven't mentioned, one of our speakers coming up is the legal director. Leon Howard is the legal director of the New Mexico ACLU, and he is an amazing resource, and the ACLU generally is an amazing resource of support for parents who are concerned that their children might have been mistreated in schools. And I know they have a really easy way to report incidents on their website. You can just put in some basic information on their website, and they'll contact you to let you know whether there's a potential claim there.
Great, thank you so much. I think, you know, knowing that neither one of you is probably experts in the Martinez-Yazzie lawsuit, but also knowing that it is something that our community statewide is very concerned about and being very thoughtful of, I want to get to one of these questions that's in the chat that says, do you think that the Martinez-Yazzie or the Yazzie-Martinez would have been different if the Black Student Education Act had existed previously? Senator Pope, can I start with you? Any thoughts that you might have on that?
Sure. You know, there's no way of knowing, but I would say I don't think it would be different personally, because we had the Indian Education Act, I believe, in 2003, Hispanic Education Act in 2010. And this was case was, you know, done after that. So I think we would have still had the same issues. I think what a lot of people don't understand and don't know as well is we have these acts, but in a lot of ways, they're not even fully funded to really implement the programs within PED in the school districts. So that's an issue there. Is the implementation and the funding, and that's something we push for. I know on the Black Education Act, we're still trying to get more money. We put some initial junior money in there, but it's a fight to just get the funding and finance because when it comes down to it, that's just not an area that they want to put money into.
Professor, did you have any thoughts on that question?
Sure. Actually, I would love to know from the, if there was a specific reason. I agree with Senator Pope. I don't think it would have been different. And the court, Judge Singleton specifically said that 4 different groups were being denied their right to education under the state constitution. She didn't explicitly mention Black or African American students, but she did, again, talk about children who are low income, in low income families, Native American students, English language learner students, which we do have, at least in Albuquerque, some students coming from who would identify as Black, who coming, who are here in our schools, coming from other countries, and then students with disabilities. So I think they're kind of really separate, actually, the Black Education Act and the Yossi Martinez case.
Thank you so much. And I just want to quote Kathy McGill from the chat here, who says it is gross receipts tax, not critical race theory at play. And so it really is about what we're funding and showing our values through our policies and the programs that we fund when we're talking about all of these things. And so I want to thank both of you so much for your time here. All of the information that you have given us today really calls for this conversation and the necessity of this conversation, and calls for us to take next steps after this in a call to action. So thank you so much for being here. We're going to end this workshop, and then we're going to take a 5-minute break. And I hope all of you will join us in 5 minutes at 3 o'clock to really look at what are the innovative things that are already happening here in New Mexico, and what are some more things that we can push for. Thanks, everyone.
Thank you all.